Cara Schulz.
Committee persons, members of the audience, I'm Cara Schulz, and I'm here representing the Libertarian Party of Minnesota. Libertarians ascribe to an ethic of assuming good faith until proven otherwise, and I mention this because we believe every person in this room is here because we all have this shared wish for a peaceful society, and so do we. But we do have significant concerns regarding HF 1605. While we do not believe it is the author's intent, this bill is discriminatory in its nature towards minorities and persons in lower socioeconomic classes. A wealthier person is able to easily hire an attorney, experts, that type of thing, to defend themselves against accusations that they pose a danger, and they can recover their civil rights. Lower income persons would be at a serious disadvantage. As for minorities, well, we did hear from Ben Rust, who works with gun trust and firearms issues as an attorney, and he notes the majority of his clients who need to take legal action to recover their rights regarding firearms are often named Mohammed, and that's not a coincidence. We also have concerns regarding inadequate due process. A person can be stripped of their rights first due to someone's feeling they may pose a danger, and then they have to go to court to recover their rights, and we feel that that is backwards in the process. Now, there is a standard used by court, which also has a concern for us, which is preponderance. And that means a judge just needs to feel about 51% that a person could possibly be a danger. And that standard is far too low for something as serious as stripping away a person's civil rights. We are concerned that this bill is ripe for abuse. Not only could feuding family members use it as a way to retaliate against one another, if you've been in family law, you've seen this, or try to gain possession of valuable family heirloom firearms, it could be used in very tragic ways. Now, if a wife were to leave her husband due to abuse and purchase a firearm for protection, an estranged husband could use this process to disarm her. Well, we see there is a provision in the bill that speaks to these false allegations, and we appreciate that. We all know that this is extremely notoriously difficult to prove and prosecute. Now, we can see the aim of this bill looks squarely at mental illness, but we believe the results would be counter to what the bill's authors hope to achieve. Provisions that allow for notice to be served in a local newspaper would broadcast to the public that the named person is mentally ill and dangerous. Provisions which allow a person's private medical records to be given to police would make people far less likely to seek assistance if they need help, and less likely to discuss serious health concerns like depression or anxiety with their family doctor. The entire bill unfairly, according to every scrap of research available, stigmatizes those with mental health challenges as violent and untrustworthy. We question the focus of this bill. If the goal of the bill is to protect the public from people who pose such a danger to themselves or others that a court must take emergency action, the bill would be about removing the person to a safe location for 72 hours for evaluation by trained medical professionals, not leaving them on the streets where they still pose a danger to themselves and others. Now, Minnesota already has a law to involuntarily evaluate someone suspected of posing a danger to themselves or others over a 72 period. And that is the tool which could be utilized, not just for public safety, but to compassionately offer mental health services to those in desperate need. The Libertarian Party of Minnesota opposes this bill due to its discriminatory nature, potential for abuse, inadequate due process before stripping a citizen of a civil right, violations of medical privacy, stigmatization of mental illness, and ineffectual focus. Thank you.
Thank you.